Hi everyone, this is Ifama Odunlami, immigration attorney from the Odunlami Law Firm in New Jersey. As you all know, even though I'm in New Jersey, my law firm serves clients in all 50 states and abroad if you're looking to come to the United States. So, the mission of our law firm is to educate fellow immigrants about their immigration rights. And I say fellow immigrant because I am an immigrant myself. I came into the United States about maybe 30 years ago. I was a student. I went to law school, graduated, tried to figure out how to get work permit, how to get my green card, and the whole rigmarole of being legal in the United States. The fear of USCIS, which was called by a different name then. I've been through it. I came to the United States. I helped my siblings come over. I filed for my mother, and that has changed the trajectory of our family, right? So you getting your green card or your citizenship is something that when you do it, you can also bring your family members here. That's part of the immigration. It's keeping families together. So I'm on Instagram, I'm on Facebook, I'm on YouTube, and so I will say hello to everyone who's joining me. Thank you so much for joining me. And today, I haven't been. I wasn't. I don't. I'm not sure if I was on last week because I went to Florida. I had a conference. So if you're in listening to this, please say hello, wave, so I know I'm not talking to myself. I went to a conference last week, work-related conference. And as you guys know, as attorneys, we are required to do something called continuing legal education. We continue to educate ourselves about the law, the changes in the law. We continue to figure out how we can help our clients. And that's why it's important for you to get a proper consultation with a lawyer that practices in the area that you're looking for. Because the reason I'm saying this is because in the past couple of weeks, I've gotten a lot of consultations from people who hired paralegals or notarios to fill out this paperwork for them. They got denied, they got in trouble. And the reason was because the notarios and the paralegals, they may know how to fill out the forms, but they're not up to date with the law. And they may not know whether your particular story may be a problem for the immigration benefit you're looking for. So what do I mean by that? Let me explain. So sometimes people come to my office, even maybe somebody who wants to naturalize. I have to dig deep into the history, right? Because sometimes in your effort to get naturalized, you may lose your green card because maybe there might have been something that you did in the past or something that happened. You might have a criminal background, or maybe there's just a whole bunch of things that could go wrong. So even if you have a naturalization, which you may consider a really easy thing to do, you really want to talk to a lawyer. And a good lawyer will go through the history of your immigration history to make sure that filing for that relief is not going to um, make you lose the green card you have. So let me say hello to people who are joined in. Hi, Hash Hash, how are you? Nice to talk to you. And Tyrone. Hi, Tyrone. Hi, how are you? So I have a topic actually. So I will get into it in a little bit, but I want to just talk about the importance of getting a proper consultation. And now I want to talk about timeline because also in the past couple of weeks, I've had people who had an immigration relief, but they didn't realize it. So the time had passed and they no longer qualified for that relief. So part of the reason I'm doing these videos is because I want you guys to know what's out there, what the news is, what the current news is. I want you guys to know your rights because we're no longer going to be immigrants that don't know um, what our rights are, and endanger our chances of getting a green card or becoming U.S. citizens, right? So it's really important that you understand and you stop. Give me a second. I need to my phone here. Okay, good. You want to make sure that you're no longer listening to family and friends who may not be giving you the right information. Chances are they're not giving you the right information because they probably heard it from somewhere. You want to come to the source, right? So Today I will talk about VAWA myths, right? I know that you guys know what VAWA is, Violence Against Women's Act, right? You know, I talk about VAWA all the time. And the reason is because I want to make sure that if you qualify for VAWA, that you're filing this paperwork because it's a relief that is very empowering. What do I mean by that? It's very empowering because you are self petitioning. You do not need your spouse to petition for you. You do not need your spouse to be in a good mood to petition for you. It is you petitioning for yourself. You don't need your spouse to file an affidavit of support, nothing. But you must make sure that you qualify to meet VAWA because every VAWA application is not being approved. As a matter of fact, a lot of VAWA applications are being denied because people think that if you just write a story, then you get your application approved. That's not the truth. So today I want to talk about the myths of VAWA so that you know what you need to be looking out for. And I always recommend that if you're going to file a VAWA application, you want to use an attorney because and you want to use an attorney that specializes in VAWA. So the first myth we're going to talk about is those that believe that VAWA only applies to women because of the name Violence Against Women's Act. Now, I'm not sure why they won't change this name. I guess they figure everybody must know it doesn't apply just to women. But that's the name, but it's just an acronym. VAWA applies to men, applies to women, applies to children, applies to parents. VAWA applies to people in same-sex marriages. The only caveat to that is the marriage must be recognized. Like if you're marrying, if in a same-sex marriage, that marriage must be recognized in the state or the country that that you got married in, right? So if you are, if your marriage is recognized in your country, then USCIS will recognize it, right? So, but typically a lot of people here are they're married to US citizens or green card holders, and so that isn't typically an issue right here. So VAWA applies to couples in marriages if you're married to a US citizen or a green card holder. VAWA applies to parents who have children who are US citizens and the children are 21 and above, right? VAWA also applies to children of US citizens or green card holders or stepchildren of US citizens or green card holders. So sometimes, for you to qualify as a stepchild, and you must listen to this because this is important, the marriage that formed the step relationship must have occurred before the child turned 18, even though you can file for VAWA until you're 21. And sometimes, depending on the reason why you didn't file when you were 21, it could actually be extended to 25, right? So you need to know that to be a stepchild, the qualifying relationship must have been formed before the child was 18, right? And another aspect of VAWA that people don't realize is if you have a child that's been abused by the US citizen or green card holder, even if you, the parent, was not abused, you can file for VAWA based on the abuse that your child suffered, right? So those are the little things that people do not know. If you were to talk to an attorney who did a lot of VAWA cases, they would be able to tell you that you qualified. And we have people who come to my office thinking that they qualify for something, but we're able to find out that they actually qualify for something else, or something else that may actually get them their green card faster. For instance, somebody may come, wanting to file for their sibling, and it's faster if you file for your parent, who can now file for the sibling, right? Depending on the age of the sibling, because we all know that filing for the sibling is the longest route to getting a green card. Okay, so we've talked about the first myth, which is that VAWA only qualifies for women, only applies to women. It doesn't. We all know now that it applies to men, women, children. Okay. Now, another thing that another misconception that people have is that USCIS will contact your abuser. USCIS will not and cannot, by law, let your abuser know that you filed VAWA. VAWA is confidential. So what does that mean for somebody who wants to file VAWA? Well, what it means is that if you decide you want to continue living with your abusive spouse because for some reason, maybe financial, you're not able to get out of the relationship at that time, you can do so even if you are living with your abusive spouse. And your abusive spouse is not going to know because USCIS will not tell them, right? They cannot tell them. Or if you're, say, divorced from a US citizen, right? Or you've left them, maybe they filed a case for you, but USCIS still cannot tell them that you've decided to file VAWA, right? They can't tell them anything. And if that spouse, gives information, false information to you about you to USCIS, they cannot use what your spouse said because they're not required. They cannot do that by law. So for those who are afraid that if I leave my spouse, they're going to call USCIS and tell them I did this or I said this, or say it's not a real marriage, because typically that's what abusers will try to threaten you with. You should know this, that USCIS cannot take that information and they cannot use it against you. So do you see now how getting information empowers you? Because when you know this stuff, then you're less afraid, right? So USCIS will not contact your abuser. VAWA is confidential, okay? You can be with your spouse while you file VAWA. You can leave your spouse or, whatever. But if you're divorced from your spouse, remember this. You must file your VAWA petition before the second anniversary of the divorce, right? And follow up to that, if you're filing a VAWA petition, make sure that your previous relationship, your previous marriages were properly terminated, right? So I have a question on Instagram. So let me answer it real quick and then I'll continue. So Finest Shandy. Finance Shandy says, a quick question about SIDGE. When can a beneficiary file for either parent if she got it by the age of 21 years? So that's a convoluted question, so I'm going to break it down. First of all, if you apply for SIDGE and you get a green card through SIDGE, that's Special Immigrant Juvenile Status. If a minor gets their green card through Special Immigrant Juvenile Status, they cannot file for their parent. That's something you need to know. They can never file for their parents if they get their green card through SIDGE. So I think that's what you're asking. So I know you have something that says if she got it by the age of 21 years. Typically, you can only apply for SIDGE if you're under the age of 21. Your application must be in before you turn 21. In most states, in other states, it's 18. So I hope that was helpful. So I'm going to go back to my presentation. So now the third misconception about VAWA is that VAWA the abuse that you suffer in VAWA has to be physical. Now, this is the biggest misconception, right? We know that abuse, emotional abuse, psychological abuse can kill. It can destroy the soul of the person who's been abused just as much as physical abuse. So the law is clear on that. To file for VAWA, you should show either extreme cruelty or physical abuse, not both. So extreme cruelty pretty much means emotional abuse, psychological abuse, financial abuse, verbal abuse. Separately or together, they could show extreme cruelty on the victim, right? So if somebody tells you that you have to show, you have to have suffered physical abuse, you have to be beaten, please know that that's not true, okay? If you're suffering from extreme cruelty that your spouse has perpetrated against you, you could qualify for VAWA. So I think the fourth misconception, I already addressed it, which says you must be married to your abuser. No, you don't have to be married to your abuser. You must have been married to your abuser at some point, of course, because you only get VAWA through marriage. Now, remember that there are some common law states, I think there are 13 of them in the United States, where the law, regards them as married, even though they're not actually married, but they're married via common law. You can file VAWA if you live in those states, right? Even if you don't have an actual marriage certificate. So that's an exception to that. So you do not have to stay married to your abuser to be able to file VAWA. It's your choice, right? If you decide to divorce, you must be divorced. You must file your application within 2 years of the divorce. That's really important, okay? So the fifth misconception is that you have to have a police report. Now, this is a misconception that I have seen even attorneys, some attorneys have, because I have people who come for consultation and they're like, I was going to file for VAWA, but the attorney said, well, I don't have a police report, so I cannot file for VAWA. Take it from me. You do not need a police report. Is a police report helpful? Of course. But VAWA requires credible evidence. That's the standard. So you do not need to have a police report. If you've suffered abuse and you can, you know, you can give your story and you can provide other evidence, right? It doesn't have to be a police report that show that your story is credible. You can qualify to file for VAWA. So you need to know this, that you do not need a police report. All right. So the sixth misconception says that you need to have photos to prove abuse. Again, that is not true, because there's nothing shows, I mean, emotional abuse and psychological abuse, you can't really, there are no pictures, So the best way to present your story is to tell your story and back up your story with some information, with some evidence, credible evidence. And the credible evidence, I know a lot of clients say things like, well, I don't have any evidence, because people who are being abused typically are ashamed to discuss it, especially men. They don't want to tell people that they're being abused in their relationship. So they keep it to themselves, right? But let me tell you this. A lot of times you may have more information, more evidence than you realize. Because when we do our declaration interview with our client, and that's the interview where we talk to the client, ask questions so that we can really get the scoop of what's going on, our clients realize that they have more information, more evidence than they realize, because we think outside the box. We're able to tell them, well, you've just told us this. How about we get this from there? And they're like, oh yeah, I have it. I didn't even think about it. So part of building your VAWA case is helping you, think outside the box to get your evidence. All right. So the seventh misconception about VAWA is, if your petition is denied, you will be deported. That's not necessarily true, right? In this administration, that's not true, actually, right? So the important thing you need to focus on, because I know a lot of people are afraid of, getting involved with USCIS when they're not sure that they're going to get a green card out of it, is the most important thing to do is to talk to an attorney. And an attorney will tell you, discuss with you your case and help you create a strong, compelling case. Okay. So those are the myths I want to discuss about VAWA. But the most important thing that you guys need to know is it's important to stay up to date. It's important not to get your legal advice from family, from friends, from notarios, from paralegals. You need to talk to people who do this. Like I said, as a lawyer, I have to take continual legal education, 24 credits in New Jersey and in New York as well. And this is the same for all the other lawyers and in their states. We have to stay on top of what's going on in our different areas of law and in law in general. So immigration lawyers, we're constantly meeting, discussing strategies to help our clients, discussing new laws, new Supreme Court laws, new state, federal laws, whatever it is, because our mission is to make sure that we can get our clients the green card that they deserve, so that they can live in this country without fear of being deported. So let me look at Instagram. And hi, Delta. Thank you. Delta says, God bless you for always giving people hope. Thank you, Delta. I believe I'm a hopeful person. I'm a positive person. And I tell you this because I'm a product of hope, right? So when I got my green card because of a change in the law, 245I, right, that allowed me to adjust my status here without having to leave the country. And that was just a random law that the Clinton administration had put into place. So, so today may not be the day that you may qualify for something, but you may qualify for something another day because the law has changed. Look at DACA. Even though DACA is at a standstill right now, but there was a time where they were taking new applications. Now they're not, but who knows what may happen in the future. And also with regards to prosecutorial discretion, now there's a new memo out that came out, I think it was April, that's looking to remove as many cases from immigration proceedings and close them out if they have an alternative relief in with USCIS. So these are changes in the law that could benefit people who are looking to get their green card. So I have someone asking a question. So Joe, hi Joe, how are you? Thank you for signing in. And Joe says, I have somebody who submitted a lot of evidence in VAWA but didn't submit the lease document. What happened to him? Well, Joe, I don't know this person, so I don't know what happened to him, but I'm assuming that you're saying they didn't submit a lease document and you're asking what would happen to the case. Well, there's no requirement to submit any one document, right? And VAWA requires that you must have lived with the person at some point, but it doesn't require you to submit a lease document. So submitting credible evidence in VAWA is a lot of different documents. Some people don't have a lease document to submit because they're not on the lease. So that's not dispositive. That's not the reason. I mean, that's not a reason to worry about whether or not their VAWA will be approved or not. It's the totality. How was the application? How did they put together the declaration? What other documents did they submit? It's not mechanical, right? You don't get it just because you submit a lease document. You have to be able to show, number one, that you lived with that person at some point. It doesn't even have to be during marriage according to the new law. You have to show that it's a real marriage, bona fide marriage, right? And there are many things you can submit to show that, right? If you don't have a lease document. And you also have to show abuse, and you also have to show that you're a person of good moral character. So I wouldn't worry about the fact that they didn't submit a lease document. I would be more interested in what else did they submit to prove their particular abuse and to prove that it was a valid marriage. Okay. Well, thank you for that question, Joe. All right. So, okay. Finance Shandy says, thank you so much for the info. You're welcome, Finance Shandy. So, I don't see that there's any more questions, so I'm going to sign off. I'm going to try to come in. I try to come in here as much as possible. But next week, I also have another conference for lawyers. So I will try to at least stop by at least once next week. But if you subscribe, you'll get to know when I join, when I start a video. And please like and please share this information to anybody who you think this will be useful to, because like I said, there's nothing as painful as having somebody come to your office who could have qualified to get a green card but came too late. Okay, so that will be that for now. It was a pleasure talking to you guys. Take care, and I will be in touch again. Bye-bye.